The case against Devon and Cornwall police is one of pregnancy discrimination. Pregnancy discrimination these days rarely happens blatantly, and I suppose one could say that is fortunate, dare I say, for want of a better phrase. But indirect discrimination is still discrimination nonetheless, and employers need to be clear on where they stand in this regard, and hopefully this case I'm about to tell you about will give you an illustration of some of the considerations that employers need to be thinking about, and perhaps employees who may find themselves victims of this, and what you can do about it. The case, as I mentioned, against Devonshire and Cornwall police concerned a pregnant policewoman who was forced, essentially, to move from being on the front line to the front desk in terms of her job role. Her superiors had considered that the fact that she was pregnant meant that this move was necessary and that she would be much safer if she was doing a desk job as opposed to being on the front line, being out and about and on the field. Now, while it may come across that they had her best interests at heart, the claimant very much took the opposite view, and in many respects she felt that this particular change would harm her career. As a result of this, she suffered from anxiety, depression, and even frequent migraines, which, for what it's worth, when people are under the stress of discrimination or in different cases bullying, etc., these sorts of bodily and mental reactions are very common. But in any event, the claimant's signs and symptoms meant that she then had quite a long period of absence from work. She brought a claim, and the employment tribunal found that she had indeed been the victim of indirect discrimination. That being that it seemed to be the case that pregnant officers, and therefore women, would be in a position potentially in future where they would have no choice but to be moved from whatever position they might be in to something else which the employer, as opposed to medical evidence or indeed the employee herself, considered safe. That means that they would have moved from an operational role to a non-operational role, as it were. And this practice or provision or criteria that the employer in this instance had was a clear sign of indirect discrimination, and there did not seem to be any justification for it. So you might be an employer who finds yourself on the back foot in this regard, or perhaps you want to know more, or perhaps you want to have a think about how your policies and procedures can best protect you and how you can train your staff. Well, I'm here to help. Equally, you might be an employee and you may be feeling like you are a victim of direct or indirect discrimination with regard to your pregnancy. You're welcome to get in touch. Again, if you need an employment solicitor on your side, get in touch.